The American Law Institute Continuing Legal Education presents Ethics of Ex Parte Communications, today's lessons from the Watergate Special Prosecution. Hosting today's program is the Honorable Paul Diamond, Judge of the U.S. District Court for the Eastern District of Pennsylvania, moderating. Stephen Gillers, Elihu Root Professor of Law, New York University Law School, New York. The Honorable Margaret McCune, Judge, U.S. Court of Appeals for the Ninth Circuit in San Diego, California. Stephen A. Salzberg, Wallace and Beverly Woodbury University Professor of Law, Co-Director of the Litigation and Dispute Resolution Program, George Washington University Law School, Washington, D.C. Jeff Shepard, author of the book The Real Watergate Scandal, Collusion, Conspiracy, and the Plot That Brought Down Nixon, in Media, Pennsylvania. And Carolyn Short, of Reed Smith LLP in Philadelphia, Pennsylvania. We will now begin our program.
Hello everyone, my name is Paul Diamond. I am a member of the ALI and a federal judge in Philadelphia. I am here with a very distinguished panel to discuss materials relating to Watergate. The panel is comprised of Professor Stephen Gillers from NYU Law School, in my opinion, our national authority on judicial and legal ethics. Judge Margaret McCune from the Ninth Circuit, where she has served since 1998. Professor Stephen Salzberg from the George Washington University School of Law. For my money, our national authority on federal criminal procedure. Jeff Shepard, the man who brings us all together, who worked in what I will call the Nixon White House from 1969 after he graduated from law school through 1975. And Carolyn Short, for my money, one of two or three preeminent litigators in Philadelphia who served as a longtime prosecutor. I will begin by calling on Judge McCune to give those of you younger than the members of the panel a primer on Watergate.
Well, the term Watergate scandal has certainly become part of our lexicon in the United States. And to some of you, it really does occupy a prominent place in your memory of legal landmarks. To others, it might be a distant memory, and of course, a number of you were not born at the time of Watergate. It all began in 1972 when 5 men broke into the headquarters of the Democratic National Committee, which was housed at the Watergate complex in an office and apartment building in Washington, D.C. And that really spawned a remarkable series of events. Soon after, there was evidence linking those burglars to President Nixon's associates and his reelection committee, which was called CREEP, the Committee to Reelect the President. Before the burglary, in the spring of 1972, there was a critical meeting took place in the Attorney General's office to discuss the intelligence plan for the campaign. And present at that meeting are several gentlemen about whom you'll hear later in the program. Of course, the Attorney General, John Mitchell, John Dean, Jeb Magruder, and Gordon Liddy. Soon after the break-in trial, just the following year, those individuals were convicted. There were 3 of the burglars convicted, along with 4 Cubans who had assisted them in that endeavor. In February 1973, the United States Senate created the Select Committee to investigate Watergate. Soon after that, the cover-up began to collapse, and so President Nixon, through his offices, appointed a special prosecutor, Leon Jaworski. And today you'll hear much about what happened after the special prosecutor was appointed. That ultimately led to the resignation of President Nixon in August 1974. And the following year, there were a number of convictions in the cover-up. Again, a discussion that we'll have today. This has left us, of course, quite a legacy in politics, books, film, and language. In books, we're all familiar with the now classic All the President's Men by Washington Post reporters Woodward and Bernstein. There were other books, Final Days, and of course one of the books which spawned this program, Jeff Shepard's book, The Real Watergate Scandal. Movies, we recall the Frost-Nixon movies and All the President's Men, also made into a movie. And of course, the other thing that turned out is that we have a new code word for gate. That has come to mean scandal in every form. We have Pizzagate, we have Donutgate, Billygate, Bridgegate, Travelgate, and it's even been exported, and overseas we had Horsegate for selling of horse meat in London, and Nutgate for Korean president's daughter who insisted on nuts not being served on Korean airlines. But important to all of us, it has left a legal legacy. Probably first and foremost, we have a major Supreme Court case, U.S. v. Nixon, and that's where the court ordered Nixon to turn over these secret tapes, and it established the contours of executive privilege. It also made ethics take on a new meaning, and so for the first time following Watergate, ethics was a required course in law schools. It is, of course, part of the multi-state professional responsibility exam, and now ethics has become more and more important both to lawyers and judges. Our program this morning will focus on what is a newly discovered implication from ethics and Watergate.
Thank you, Judge McKeown. I will now turn the floor over to Jeff Shepard, whose research over the last 40 years, really, has uncovered any number of documents that form the basis of our discussion today. Jeff, however, right now is going to give our viewers a quick summary of the major players in the scandal.
Thank you, Judge. I should mention at the beginning to those of you who wallow in Watergate that the first special prosecutor was Archibald Cox of the Harvard Law School, but he only lasted 6 months when he was politely asked to resign in what's called the Saturday Night Massacre. And Leon Jaworski is the one who presided over the Watergate Special Prosecution Force and all of the trials. But he was officially the second special prosecutor. You now have before you a slide showing the pictures of the principal Watergate defendants that we're going to be discussing. The row across the top, John Mitchell, Bob Haldeman, and John Ehrlichman, are the ones who were convicted in the Watergate cover-up trial. Convicted on all counts of conspiracy, obstruction of justice, and perjury. John Mitchell was President Nixon's Attorney General, Bob Haldeman was his Chief of Staff, and John Ehrlichman, my boss, was Head of Domestic Affairs. The line across the bottom, if you will, are the people who actually got their hands dirty doing the crimes. Gordon Liddy is the first picture. He planned and supervised at least 3 illegal break-ins. Jeb Magruder was his immediate superior at the committee to re-elect the president's re-election committee, and he's the one that ordered the break-in, which really was the 3rd break-in, ordered them to go back in, and he was the first level that the cover-up was trying to protect. You understand from the outset the Watergate scandal is based on 2 irrefutable facts. There really was a break-in, and there really was a cover-up. Now, John Dean, the 3rd picture along the bottom, was counsel to the president, but John was worried once the break-in people were arrested about becoming involved because he had recruited and hired Gordon Liddy. He had discussed with him the campaign intelligence plan. Indeed, he had been present at 2 of the meetings in the Attorney General's office where this was discussed, and that he had run the cover-up. He has said in public forums that he acted as chief desk officer for the cover-up. When the cover-up collapsed, and it should have, John Dean and Jeb Magruder were the first ones to run to the prosecutors and offer their testimony against their superiors in exchange for leniency. And what happened was that after 2.5 years from the break-in to the demise of the Nixon's own presidency and to the Watergate cover-up trial, the jury believed John Dean and did not believe the denials by the three across the top, and they were convicted and they were sentenced each to 2.5 to 8 years in prison, and each served 18 months. So we're going to get back to how those convictions were obtained, but first we're going to have Professor Gillers walk us through the ethical standards on ex parte meetings between individuals involved as this scandal unfolded.
Thank you, Jeff. Well, a premise of the adversary system then and now is that neither side to a dispute gets to speak to the judge or to the jury without the other side being present, or at least having the opportunity to be present. Neither side could present written documents to the judge unless the other side gets a copy of those documents and can respond to the judge as well. And so what we have are rules then and now governing both lawyers and judges with regard to what are called colloquially ex parte communications, communications from one side only. The rules then differ from the rules now, and we're going to look at all of the rules to see how they differ. So on the screen now is a rule governing lawyers as of 1972, 73. And the key words here, we're going to come back to them later, are in an adversary proceeding, certain communications shall not occur without an exception. Those are on the merits. The word merits is in there, the merits of the cause. And the final three words is, while the proceeding is pending. So that word pending is going to come back to our discussion. If we go to the next slide, we see that there are certain exceptions. They are very narrow, and they are meant to ensure that no one gets an advantage, even in the event that for some compelling reason there has to be an ex parte communication. You will notice also that in this rule, there is no use of the phrase ex parte. We do have reference to the word party, but not ex parte. And then we have the rule as it exists today. And this is ABA Model Rule 3.5b. If you look at the second bullet, we do have the phrase ex parte, shall not communicate, a lawyer shall not communicate ex parte with a person during the proceeding unless authorized to do so by law or court order. And then we're now going to move to the rules governing judges, because just as lawyers are forbidden to communicate with judges ex parte, so are judges forbidden to receive ex parte communications unless ordered, unless allowed by law. So here we have the 1972 ABA Code of Judicial Conduct, which was at the time as well the rule that governed federal judges. And here you see a new word. In addition to the phrase ex parte, you see the phrase a pending or impending proceeding. So the proceeding doesn't have to be then in existence. It need be only impending, foreseeable, for this rule to attach. And that word impending is going to become important to us. And now we have the current rule for federal judges, which differs a bit from the rule for state judges as proposed in the ABA Model Code. And here we see the word ex parte again. And here we also see that the rule applies not only to pending, but also impending matters. And finally, we see that a judge who receives an unauthorized ex parte communication must take steps to ensure that the other side is not disadvantaged. And finally, we have in the current rule for federal judges a prohibition against a judge initiating, permitting, or considering ex parte communications if forbidden by law. But then we have a brief paragraph allowing some in unusual circumstances, but again protecting against any opportunity for one side to get an advantage by virtue of the ex parte communication with the judge.
Thank you, Professor Gillers. These ethical provisions will in part frame the discussion we will have regarding documents that Jeff Shepard has unearthed, as I say, over the last 40 years relating to the investigation of the Watergate break-in and subsequent prosecutions. And along those lines, the other part of the framework will be the law governing criminal investigations at the time and now, namely the law governing the conducting of grand jury proceedings and the secrecy considerations that are part of that. And for that, I will call on Professor Salzberg.
Well, then and now, the grand jury has been regarded as an independent body. The function of the grand jury is not to decide guilt or innocence. It's to decide whether there's probable cause to charge a defendant with committing a particular crime. One of the things we're going to be dealing with today is the unusual evidence that prosecutors were meeting with the judge who presided over the Watergate trials. Actually, the meeting with two judges who were responsible for the Watergate trials. And the subject we'll be addressing is whether or not these meetings violated the rules governing lawyers that Steve Gillers talked about and the rules governing judges that he talked about. And we're also going to be dealing with at least one instance of a meeting between a prosecutor and a judge that didn't involve the grand jury. It involved, in fact, it's our first example. It involved the judge meeting with the prosecutor right before the first group Watergate defendants went on trial to apparently tell the prosecutor how the judge thought the prosecutor should proceed. But as far as grand juries go, we will be seeing, as we talk about this, some very unusual developments. There's a concept called grand jury secrecy, which is codified then and now in Rule 6E of the Federal Rules of Criminal Procedure. It essentially says grand jury information shall not be disclosed except to attorneys for the government in the exercise of their duties. And as we get there, we will learn that grand jury material was in fact disclosed to the United States Congress and disclosed essentially with the assistance of the chief judge who was presiding over the Watergate cases.
Thank you, Professor Salzberg. I'm going to now call on Jeff Shepard to begin his rather lengthy walk through publicly available materials and materials that he has unearthed through Freedom of Information Act requests and extreme research diligence over the last 40 years. Jeff, could you begin with the very first document that you have provided us with from Judge Sirica's book, and perhaps you should first tell us who Judge Sirica was.
Sure, and thank you, Judge. We have, and you can see on the screen, there's a summary chart showing that we're going to discuss 9 different instances of ex parte meetings between Judge Sirica, who presided over the break-in trial and the cover-up trial. He was chief judge of the District of Columbia courts, and as chief judge, he had the authority to appoint the judge who would preside over the trial, and he appointed himself.
And he also supervised the grand jury investigation.
He also supervised all grand juries within the District of Columbia. I believe that's still the rule in the District of Columbia. The chief judge supervises the grand juries. The first instance of a ex parte meeting is taken from Judge Sirica's own book. He wrote a book that was published in 1979, and in that book he talks about his meeting with Earl Silbert. Earl Silbert is the career prosecutor who ran the investigation of the break-in. He was principal assistant United States attorney for the District of Columbia. And here's what Judge Sirica says in his book at page 38. I like Earl Silbert. I think he's a good lawyer. I wanted to be helpful, to share with him some of my experiences, which I felt might give him some guidance through what was obviously a tough situation. A few days before the trial started, he was in my chambers discussing an administrative problem unconnected with the Watergate case. I said to him, Earl, look, you've got a great opportunity in this case if you go right down the middle. Let the chips fall where they may. Don't let anybody put pressure on you. Before he left my office, I gave him a bound copy of the hearings conducted back in 1944 by a select committee of the House of Representatives into activities of the Federal Communications Commission. I wanted the young prosecutor to know just how whitewashers were engineered, and I wanted him to know that I had had direct experience with cover-ups while serving as chief counsel to that committee. So our first instance for discussion by the panel is whether under any circumstances it is appropriate for the judge about to conduct a trial to instruct the prosecuting attorney on how he thinks that trial should be conducted.
Well, perhaps, Jeff, that's certainly one way to construe this. I just view this as Dutch uncle advice that I personally have never given or received, but I would call on Professor Gillers first. Do you think this was appropriate action by Judge Sirica, again, assuming it actually took place?
Well, on the ex parte issue, there's no problem. There's no other side, there's no proceeding, there's no discussion of the merits of the matter. So the rules we talked about earlier, then and now, would not forbid this conversation. Those are not the only rules, and probably in this conversation among our panelists, we'll be referring to other rules as well. My view is that it is more than Dutch uncle. It is advertisements for myself. I mean, it sounds like the judge is promoting his familiarity with factual and legal issues that may come to underpin any eventual prosecution. Now, what he expects to reap from this, if anything, whether it was part of his consciousness or not, we don't know. But we really want judges to be umpires, to be telegraph total neutrality, and it seemed to me that he was in some indirect way letting Earl Silbert know that he was knowledgeable about these things.
Professor Salzberg, do you think that it really comports with the presumption of innocence regarding the defendants that were about to be tried before Judge Sirica for obstruction of justice, that I wanted the young prosecutor to know just how whitewashers were engineered? I had direct experience with cover-ups.
Let me confess to a bias. Earl Silbert's a hero of mine. Earl Silbert's one of the finest lawyers I know, a U.S. attorney that everybody respected. He was apparently before Judge Sirica on an administrative matter, nothing to do with the trial that's coming up. And then the judge jumps in unilaterally, according to his book. Now, if I'd been the lawyer there, I mean, you would patiently listen. Judge apparently is worried that we haven't had a situation like this, where you have maybe the White House implicated in a break-in in the other party's headquarters. And he's worried that this young prosecutor is going to face a kind of pressure that young prosecutors rarely see. So you used the phrase Dutch uncle. It seemed to me that's what he was doing, and I think Professor Gillers is also right. He was boasting a little bit about his own experience. But if you're in the shoes of Earl Silbert, you hear him out and get out of that chamber as fast as you possibly can.
Carolyn, have you ever had a judge be this helpful to you when you were a prosecutor?
Never. But I would have one question about this that I would put to Professor Silver is, wouldn't under the 1972 ABA Code, where it has the word impending proceeding, that if Judge Sirica, as he said, approached this, and the way I read this is sort of the Dutch uncle, but also sort of saying, I'm your cheerleader, I'm here to help you kind of thing, by saying this is how whitewashers work. Would it be, wouldn't that be a violation of the 72 ABA Code of Judicial Conduct to discuss with him, because the matter, if I'm right about the definition of impending, it really would be impending?
Well, and Jeff can help us here, but this conversation occurred pretty soon before the break-in trial was about.
That's correct. This was in anticipation of the break-in trial, which was tried in January of 1973.
And this conversation was?
Well, we don't know because he doesn't date it.
Oh, he
but
doesn't.
my assumption is that it occurred in November or December beforehand. So you knew who the defendants were. They were indicted on September 15th.
And it would have presumably been before Archibald Cox was appointed, because Earl Silver...
Oh, absolutely. The cover-up collapsed several months after the burglars were convicted in the break-in trial.
Okay.
So Professor Gillers, would you think that changes it, or?
No, I think that you don't need the word impending, because this is pending. Okay. This is a pending matter. It just hasn't, the trial hasn't started yet, but the matter is on the calendar, it's pending. Now, that doesn't solve the problem or answer the question entirely, because one has to ask, what was the substance of what he said? Did he tell him how to try the case? No. I still see it as, I know how this is done. Don't let anyone pressure you. I mean, that the advice he gave about not being pressured is gratuitous. I mean, of course, Silbert would know he should not be pressured. So I just think I call it gratuitous, unnecessary, unwise, but I don't see that the content crosses the line.
This reminds me of the Caine Mutiny, where Captain Queeg talks about the cheese investigation and says that's the model I want you to follow in determining whether or not a key existed and the strawberries were stolen. But let's put that aside for a minute and go to our second.
How about Judge McEwen?
Oh, I apologize. Judge McEwen, I'm troubled by this contact. Are you?
I think it's a hybrid situation, as the others have suggested. It's primarily a Dutch uncle situation, I think, where he's saying, stand your ground, you're a young prosecutor, stand your ground, and he's being a judge in the broad sense of really trying to let the prosecutor know that the prosecutor has his own free rein. I think we see it as more suspicious now because we're going to see some other documents with Judge Sirica. But if you were to look at it solely standing on its own, I think it's a situation that doesn't trouble me too much. The question would arise, as it does in all ex parte cases, to whom would you report this? And I think I agree with Professor Gillers. There's really not a lot of substance here in terms of talking about something substantive about the case. If there were a substantive communication, then of course either you would need, as the lawyer, to report that to other counsel as they came into the case or as they existed in the case. But at this stage, I think it's a fairly innocuous, but it does presage what we're going to see later.
Well, as moderator, I'm going to get the last word on this, Jeff. And I have never called a lawyer, I've never addressed a lawyer ex parte who had a matter pending or impending before me and said to him or her, don't screw this up, which is how I read this. But time presses, so perhaps we can move on to the ex parte meeting with Samuel Dash.
Sure. I would, though, like to echo Professor Salzberg's comment about Earl Silbert.
You're not going to give me the last word.
No.
This isn't about Mr. Silbert.
But
maybe
Earl,
I'm being rather Judge-O centric on this. This is about Judge Sirica, as
Yes.
far as I'm concerned. And if I were Earl Silbert, I would be sitting there with a deer in the headlights look on my face. I wouldn't know what to do. You don't want to offend the judge. You don't want to say, you sure you want to be talking to me about this? You just sit there and say, thank you, your worship, and leave. He had no choice. I don't understand a judge saying, don't screw this up. I didn't screw it up when I had my great investigation in 1944.
I concur. I didn't want to cast aspersions on Earl Silbert, one of the genuine heroes of Watergate. We will go to number two. The incident number two is an ex parte meeting with Samuel Dash with Judge Silbert. Samuel Dash is chief counsel of
Judge Sirica.
I'm sorry, with Judge Sirica. Samuel Dash is chief counsel of the Senate Irvin Committee, and he's looking for witnesses. And so he goes to see his good friend, Judge Sirica. And in Samuel Dash's book, he describes the meeting, and I'll read the description from Dash's own book. I turned my attention to the problem of how to begin development of some cracks in the wall of silence which the Watergate burglars had constructed and maintained. I had no doubt our investigation was confronting a major cover-up conspiracy. It seemed obvious we would need the help of an insider, an informer, to successfully expose this conspiracy. Some extraordinary tactic had to be employed to induce one or more of the burglars to start talking. As chief counsel of the subcommittee, I had no standing in the criminal case before Judge Sirica, but I had a committee reason to meet with him prior to the sentencing date. Now, the Watergate burglars have been convicted. Sentencing was set 60 days later, so they're convicted on January 30th. Sentencing is to occur the last week of March. I had a committee reason to meet with him. Senator Irvin had earlier requested Sirica to let the committee inspect grand jury minutes of the Watergate case. On further review, I concluded that he couldn't legally grant this request. Irvin concurred in my opinion and asked me to withdraw it. This could have been accomplished by letter, but it gave me the opportunity to talk to Judge Sirica in his chambers. Sirica and I had been friends for years as faculty colleagues at Georgetown University Law Center. When I met with Sirica, I was careful to emphasize I was not recommending anything regarding his sentencing of the Watergate defendants, but I expressed the hope that one of them might give us information about the cover-up trial, and I referred him to the Swig case. The Swig case is a case in New York which occurred before this, where the presiding judge temporarily sentenced the defendants to the maximum imprisonment for each of their violations while a sentencing report was being prepared. So what you got was absolutely draconian temporary sentencing. And you have to be as biased as I am to read between the lines. But what Samuel Dash was suggesting...
Well, we'll get to that. Why don't you read the very last
Let me finish
sentence.
the quote. Judge Sirica responded he understood the committee was not making any request of him, as it had no right to do, and that he would study all the law and sentence as he determined the interests of justice required.
Professor Salzberg, I almost view this as an organized crime conversation. I know you're not asking me to do anything wrong. You're referring to a case where the judge sent somebody into the next century with a sentence, but you're not asking me to do anything. And thank you. This to me is I'm not talking about Professor Dash. I'm talking about the late Judge Sirica. This to me seems like an improper communication.
I think it's an improper communication by Professor Dash. The reading between the lines of this is we could have sent a letter, but I wanted to meet with my friend, the judge, so I could make clear that while we weren't formally asking for the judge to hammer these guys so that they would testify before us and then the judge could consider lowering their sentences, that's what he was asking. It's outrageous. in my judgment. I mean, we do know, this happens, Judge, I'm sure in your court a lot. Prosecutors.
What happens in my court a lot?
What I was going to say is prosecutors will.
Not that.
Prosecutors will say to you, Judge, we'd like to delay sentencing in this case.
Absolutely.
And it's up to you. I mean, but the defense lawyer will be heard on it. And often they say, yes, Judge, we concur in that. Because if my defendant cooperates, then the government may be prepared to make certain motions which will enable you to give a sentence that would be lower, below a mandatory minimum, for example. You couldn't otherwise give. But that's where the both sides are heard. And the judge is, the final decision maker. Judge Sirica was the final decision maker here, but another branch of government is saying, Judge, we want you to help us. It's hard for me to think of, another situation in which that occurred.
Judge McEwen, what do you think?
Let me first say that I was a first-year law student at this time, and Sam Dash was my criminal law professor. He was a fabulous guy, and we used to joke that he could drop more names in an hour than anyone else in Washington, D.C. He was funny, he was smart, but I totally agree with Professor Saltzman, both from his position as prosecutor or special counsel to the committee. I think this was totally wrong. He still is governed by the rules for lawyers, and he's approaching a judge in a case that's not impending, it's pending. We have the sentencing facing the judge in a very short period of time. So I would have said to the counsel for the committee, I would have kicked him right out of my office and said, I cannot talk about this. This is improper. And then I would have disclosed on the record the approach that had been made to me from the special counsel. It can be said here, we don't know what Judge Sirica said or did, or whether it influenced anything, but we have a situation where Sam Dash is talking about a defendant in a pending criminal prosecution and about to be sentenced that could be leveraged for his own purposes. So I can't see anything about this that leaves margins of gray.
I agree with Judge McEwen. I should point out for the younger members of our audience, Samuel Dash, Senator Ervin, these people became folk heroes because in 1974, the Watergate Senate committee hearings were televised every day, all day. I began law school in August of 74, approximately a week after President Nixon resigned. These people, to say they were well-known, to say they were celebrities, to say they became revered, would not be an overstatement. But it appears to me, Professor Gillers, that both of these men crossed the line here.
Absolutely. What they did is centrally within the prohibition for lawyers and the prohibition for judges. Sentencing is the merits of a matter before a judge. It's not some peripheral procedural issue. Sam Dash was not counsel of record, but the rule doesn't require that the lawyer be counsel of record. It's forbidden even to third parties to the matter. And so that conversation should not have occurred. And once Sam Dash came in and began to talk that way, he should have been asked to leave, and Judge Sirica should have made a note of it and should have notified both sides that this effort had been made.
Carolyn Short, you get the last.
That you have to ask yourself is, have times changed? Because I certainly noticed when I began to practice law in the 70s that there were a lot of circumstances where I would appear in the courtroom and out of the judge's chamber would come the judge and the opposing counsel. I was a young lawyer, but I know that happened on more than one occasion. Of course, I didn't know what they were talking about, but the appearance of it was more than suspect and fishy. But I think we have to realize that there is a certain camaraderie, and certainly perhaps more in the past than now, between lawyers and judges, and it raises also appearance issues by even having these meetings in the first place when there's any kind of impending case. So I'd like to think that times have changed, and I hope so.
Carolyn, what do you think?
Well, I agree with my fellow panelists for the most part on this. One of the things, I guess, that occurred to me when I was reading all of this, and I too remember quite well listening every day to the Watergate hearings in 1974, and this was a formative time in my life and part of what made me decide to go to law school. But the thing that I guess is so, puzzling to me about this is it seems so obvious, and yet Sam Dash wrote freely about it in his book, and he has such a great reputation that no one could say he was dumb or missed the point, but he clearly, as we have said already, didn't think that there was anything wrong. So how is that possible? That's sort of where, and what you said, Judge McEwen, about being in the courtroom and seeing your adversary come out with the judge has happened to me hundreds of times. But every time, and this was in the very early 80s, I knew that was wrong. And, so that's what I'm trying to figure out here is why these things are written about so much so that they believe that it exculpates them and as opposed to inculpates them.
I pose this as a theory because Professor Dash is no longer with us. Judge Sirica is no longer with us. So it's only a theory, but it does seem to me that when it came to Richard Nixon and getting Richard Nixon, which is to a greater or lesser extent what Watergate was about, the ends really did justify the means in the eyes of the American public, or a significant part of the American public, I should say. But we, again, time presses, and so I would ask Jeff for you to go to your third document, Leon Jaworski, and perhaps you should again remind us, somebody on my court, when I told him, I referred to Leon Jaworski, he asked me doesn't he play for the Phillies? And so I am assuming that there are people out there who don't know or didn't know until now who Leon Jaworski was. And so perhaps, Jeff, you could remind us.
Thank you. So this is item number 3. It was a very, very tense time. On October 19th, President Nixon demanded his Attorney General fire Archibald Cox. The Attorney General declined and resigned. The Deputy Attorney General was given the same opportunity, and he was fired for not following through. But the third-ranking officer at the Department of Justice did, in fact, fire Archibald Cox. And that is referred to as the Saturday Night Massacre.
And who was that third-ranking person?
Bob Bork, who was a Solicitor General at the time and a prime candidate to be nominated to the Supreme Court. And it's felt that Bob Bork's action precluded him ever being confirmed for the Supreme Court for this action. Because
he fired Archibald Cox?
At the instruction of the president.
At the instruction of Richard Nixon.
Yes.
Okay.
There was a scramble to find another prosecutor, and Leon Jaworski was chosen, and he assumed office on November 5th. He was sworn in on November 5th. And in the archives, we have his notes. And his notes on November 5th say, oath of office. And the second entry, without further ado, is courtesy call on Sirica. And we know nothing more than that. So the issue is, does the new sheriff in town have a right or an obligation or cause trouble by going and making a courtesy call on the presiding judge?
I'll begin this discussion by pointing out that whenever in the Eastern District of Pennsylvania, which is where I sit, whenever we have a newly appointed U.S. attorney who's been confirmed or a newly appointed chief federal defender, he or she pays a courtesy call on each and every one of us. I don't see anything wrong with this. Do you, Professor Gillers?
Nothing wrong with it.
Professor
Quite
Salzberg?
appropriate.
I think it's quite appropriate too.
Carolyn?
Agreed.
Judge McEwen?
Totally in the court.
Okay.
Let me add something if I could. If it came to light today that the newly appointed special prosecutor in today's drama personally called on the chief judge of the district court, would there be trouble?
I think that I'm one of those people who thinks that things repeat themselves over and over, and there's really nothing new. Having said that, I think with the internet, with what is now the 24-hour cycle that renews itself every day, and with the extraordinarily partisan atmosphere, if you're asking me whether or not there would be flack if Robert Mueller went in and visited with the chief judge of the D.C. District Court that was going to hear his cases, I absolutely think there would be a flap. But in 1973, when this took place, a courtesy call, if indeed it was a courtesy call, I just don't think there's anything wrong with it.
I don't think there'd be a problem with Robert Mueller making a courtesy call. After all, if he's seeking a search warrant, he's going to have an ex parte meeting with the judge anyway. So stopping by and saying, "Hi, I'm Robert Mueller, see you later," I think is fine.
I think a special prosecutor today would have problems ordering a hot dog for lunch. I think people are going to find reasons to attack or defend a special prosecutor.
I think only if the judge is serving the lunch.
And who made the hot dog, right?
Number 4.
Yes.
Item number 4. This is a memo to the file by 2 of the members of the Special Prosecution Force who were summoned on the 2nd of January to a meeting in Judge Sirica's chambers. And we reproduced the memo on the slides. There are 4 slides, and I'm going to quote from part of this memo. It begins, this is from Philip Lacavara, who's counsel to the special prosecutor, to Richard Benvenisti, who's head of the Watergate task force. At approximately 10 p.m. on Tuesday, January 1st, 1974, I received a telephone call at home from Todd Christofferson, law clerk to Judge Sirica, who stated the judge wanted to see Mr. Jaworski and me in his chambers as early as possible the next morning. When I replied that Mr. Jaworski was not expected back in Washington until noon, Todd stated I should at least come to chambers. And then on the next page, Judge Sirica asked whether we knew anything that would indicate that Earl Silbert had been the source of any leaks or had otherwise behaved in an inappropriate way in conducting the original Watergate investigation. The third slide. The judge stated that he had just received a telephone call from Sam Dash of the Irvin Committee, who had telephoned him about the remand of the committee's subpoena enforcement suit. The judge told me that he had indicated to Dash, a good friend, basically what he had told us, and apparently also indicated that he had given us this information. And then the last slide, he said Dash told him the committee had nothing adverse about Silbert and that its final report would not contain any derogatory information about him. On this basis, Judge Sirica indicated to me that since both the committee and we had cleared Silbert, he would proceed to swear him in as United States Attorney as scheduled. Now, if I may take just a moment to put this in context, the judge went to a New Year's Eve party put on by his former firm, and there he heard a rumor that Alex Butterfield is the one who reveals the existence of the White House taping system, that Butterfield had been tipped off to the questions he would be asked in front of the grand jury, and this person relaying this information to Judge Sirica said, you know, Silbert could be in trouble because this information may have leaked. Silbert was to be sworn in on January 2nd by Judge Sirica as acting United States Attorney. So the judge took it upon himself to conduct a mini investigation. If you study the memo, and I have nothing else to do, that this is what I do, the rumor is difficult on its face because Alex Butterfield never appeared before the grand jury. And what the rumor, and this happens sometimes with rumors.
Jeff,
I'm sorry. I'll stop.
I see a few weeds here, but I would like to ask Judge McKeown. I'm not sure where this fits into the Judge McKeown, the ethical framework that Professor Gillers has given us, or the legal framework that Professor Salzberg has given us. And I'm assuming that as chief judge of the district, it is one of the duties the chief judge performs, which is to swear in the new U.S. attorney, which is perfectly appropriate. I just think I'm really uncomfortable with the idea that before Judge Sirica performs what I think of as a ceremonial function, he says, I have to check this guy out. Is this guy kosher? Can I do this? I'm really uncomfortable with this.
I'm also uncomfortable. I don't think it's a requirement that the chief district judge do the swearing in if you look at the statute. But as you say, it's usually by custom and by ceremony that it's done, and typically happens often in the chambers of the chief district judge with several of the other judges and the federal defender and other individuals that are key in the district. I do think it's odd because I don't think it's really the judge's role to investigate who he's swearing in. That is, this is a presidential appointee, and it is someone, going to be operating under the auspices of the Department of Justice. So it seems, from a pure separation of powers, a very odd role for Judge Sirica to play. But I think, as we see, Judge Sirica was in for a dime, in for a dollar in this whole Watergate situation. And I think he saw his role as something bigger than it was. And it was almost like he was a grand overseer, a grand poobah, orchestrating much of what would happen in the Watergate prosecution. So in his mind, this probably made perfect sense. In retrospect, it seems very odd to me.
Picking up on what the judge just said, I read this, Professor Salzberg, as I'm not swearing in anybody who you tell me might have compromised your investigation or prosecution in any way.
I think that's right. To me, this is outrageous all the way around, because it almost is the Judge Sirica saying, I don't want him ruining my case. That's what this is about. I don't want anybody, I'm not swearing anybody in who might ruin my case. So every piece of this is wrong. What judge calls up a prosecutor at night, have his law clerk do it, say, I want to see you tomorrow? I mean, the prosecutor shouldn't have gone. To start with, he shouldn't have been there to meet with the judge, in my judgment. And then there's Sam Dash again. The investigation by the Watergate committee was supposed to be confidential. Their information was not supposed to be shared with Judge Sirica. He had nothing to do with the congressional investigation. And here he is sticking his nose into that. It's like he's orchestrating to the extent he can what the prosecutors are doing, and he's orchestrating to the extent he can follow up on that earlier visit by Sam Dash with what the Watergate committee is doing. I mean, this is bad in almost every possible way it could be bad.
You agree, Carolyn?
I really do. And I also, as I read this, and I myself have conducted a number of grand jury investigations over the course of my career, and when I look at this memo, and it's so obviously bad, at least to me, in today's era, it almost looks to me like it was written because even the author and the recipient were aware that it was bad and that they were writing this to sort of cover themselves. I don't know if that's true or not, but that was sort of the way that I read this. And it was making a record within the prosecution force of what had transpired in case anyone came back to them and said, why did this happen?
Professor Gillers, you get the last word.
I have a question for Jeff. You misspoke, but you said Silbert was sworn in as acting U.S. attorney, or was he sworn in as U.S.
acting? No, this was acting.
Well,
this was acting.
Correct me if I'm wrong, but I understood that pending the appointment and confirmation of a U.S. attorney, it is the district judges who identify the acting U.S. attorney. That's been true in the Southern District of New York. So
I don't think that's true any longer. I think that the Department of Justice selects. There are all kinds of levels. There is the interim U.S. attorney. There's the acting U.S. attorney. Maybe Judge McEwen knows the difference. I'm sure the people in the U.S. attorney's office do, but I don't.
Because if Silbert's appointment depended on a decision by the Judge Sirica, or the court, then I could see where Judge Sirica, having been participant to that appointment, might want to track down this rumor.
We've entered the era of speculation, but in that memo, at one point, Sirica says, if there's some doubt, I'll have another judge swear him in.
Right.
So I'm not soiled if something actually was wrong. But he's satisfied, so he conducts the swearing in. But I don't think it indicates the judge was picking the U.S. attorney.
I think the DOJ regs. I'm not sure there were DOJ regs at this time, but now there are nothing but DOJ regs, and I think honestly they have regulations on almost everything, and I think that they set out when a confirmed United States attorney resigns, what happens. There's immediately an interim, and then there's an acting. The interim, I believe, is usually the first assistant. But I may be getting this terminology wrong. Anyway.
Well, I think one of the other interesting things here is, what does the lawyer do? What does Mr. Lacavera do when he gets this call? I think it's odd that when he says, of course, my boss is unavailable, that the law clerk says, oh, well, then you come in, which, of course, suggests sort of an unusual role for a law clerk to be playing, sort of taking over as if he were or she were a mini judge saying what to do. So, I think Lacavera was put in a difficult position, and he tried to delay it by saying his boss was out of town. He might have just said, I can't come without consultation with Mr. Jaworski. Or there's always this option that nobody likes to pull this card, and that's to say, when you go there, well, if we're having a conversation, just for both of us, I would like a court reporter here. Now, I realize that might be dropping a cherry bomb into the conversation, but if you are a lawyer and you're worried about potentially being compromised, it's always something you can say in a polite way. And the judge says, "Oh, we don't need a court reporter. I'm just going to chat with you about, your birthday party or whatever." Well, it would have actually certainly put the issue on the table had something like that been done. And I just think that lawyers always need to think about, what are my options here? What could I do? Am I going to place myself in a situation that may be difficult to get out of? Because once you're in with the judge, then you have a more difficult and touchy situation.
Well, Judge McEwen, I agree with what you say, and as these documents will show, I think that there is a not so subtle shift from, as we go through the documents, from Judge Sirica initiating the ex parte contact to the special prosecutor's office saying, as we will see in a matter of minutes, we need to talk to the judge so that he doesn't screw this up. And they're the ones who have the idea of, now that the judge has made it clear, it seems to me, that he's amenable to these kinds of communications because he's initiated several.
All right. Item number 5 is a letter that Leon Jaworski wrote to Chief Judge Sirica, dated December 27th, 1973. The only copy of this letter was in Jaworski's confidential Watergate files. And the first sentence is what is so surprising. When Messrs. Ruth, Lacavara, Benvenisti, and I met with you and Judge Gazelle at your request on Friday, December 14th. These are the 4 top Watergate prosecutors. Hank Ruth is Deputy Special Prosecutor. Phil Lacavara is counsel to the Special Prosecutor. Rick Benvenisti runs the Watergate Task Force. And of course, Leon Jaworski is the Special Prosecutor. And it's not just meeting with Judge Sirica, but also with Judge Gazelle. We don't have any idea what they said. We only know here is a letter that begins with a recognition there was a meeting. Now, there's a second part I can come to a little bit later, but let's start with just the discussion of whether under any circumstances 4 prosecutors can sit down with 2 judges?
Well, if you read the rest of the paragraph, it says, you suggested that it would be helpful if we could provide you with some sense of the caseload that we would be generating for the court over the next several months. If that's all that was discussed, I don't have a problem with it. What do you think, Professor Gillers?
I have no problem with it. It's the business of the court. It's a high-profile case. I think the chief judge has to keep tabs on the progress, not the merits, not the substance, not the advocacy positions, but just the progress of the case in order to run his courthouse.
Judge McKeown, what do you think?
It seems on its face that it relates really to administrative matters, and the chief judge is looking at scheduling and administration. I can't say from the letter that there's something more.
Professor Salzberg, doesn't it seem to you, or why don't I put it in my own, it does seem to me that when you begin with when the 3 of us, or 4 of us met with you and Judge Gazelle at your request, there's a kind of a CYA feel to that. And if, at least to me, if all they were talking about was scheduling, why do you think he began the paragraph that way?
I'm not sure. I mean, we can read a lot in hindsight, read a lot into this, but I mean, one innocent reading is that he's following up that if this was a legitimate administrative meeting where they talked about what might be coming, then the next paragraphs basically go on to say, now I foresee, and they talk about that grand juries, plural, are going to be issuing indictments, so that one reading is it's just a follow-up to that meeting, which was an administrative meeting, and that they're filling in the chief judge on what the courthouse could expect, as Professor Giller said, so that if there's going to be some real action in the courthouse, the court will be ready for it.
Carolyn?
Well, again, I sort of have the same feeling that, if you are having an administrative meeting with the judge, that it's not a problem. On the other hand, I again feel that this is a document that is written as a self-protection document, or trying to make the meeting appear to be something other than it was. And I read that by this at your request language, that these are very seasoned prosecutors in the highest profile investigation in the country at the time, and I don't think they use their words loosely, and they put that in the first sentence, at your request, and administrative, as though it's something that you would see, and I'm a very suspicious-minded person, it's something that you would see where you wanted others who might be reading this later to believe that these prosecutors had nothing to do with going to the meeting. They didn't initiate it. And that it was only about what they describe as a follow-on. I mean, that's just my suspicion. I don't know whether that's true.
I think it's a framing sentence. What he's saying is, at this meeting, you asked us for certain information, and now I'm going to give you the information. So I see the lead-in sentence as a reminder of what you requested and which I will now provide.
Could I ask Jeff a question about this? More disturbing than anything are the handwritten notes.
They're mine.
That's what I figured. That's why I didn't ask. That's what I thought.
You have a very disturbing tendency, Jeff.
There are so many records that I made notes of my concerns on the way through, and I'm remiss in not wiping them out.
Yeah, well, so that anybody who's watching this and seeing it will know that is not something they should be concerned with.
Jeff sort of tantalized us with what he wanted to talk about with respect to the letter later, and I believe that's the schedule of indictments that Jaworski is providing Judge Sirica with, and we will get to that because the schedule of indictments, to give the audience a foretaste, will determine which judge gets to assign the cases once the indictments are returned. But why don't we move on to document 6, Jeff?
Sure. In document 6, we have the handwritten notes from Associate Special Prosecutor James Vorenberg. Vorenberg was assigned the responsibility for keeping track of the Special Prosecution Office decisions so he could author the report when they were through. And those notes have surfaced recently at Harvard's Law Library. And this particular notation attracted my interest. And he's talking about that the topic is the president. He always notes what the topic was. The memo written by Carl Feldbaum and others recommending Nixon be indicted is a cause of frustration in the staff because Jaworski told them he'd already reached an agreement with Sirica several weeks prior and without disclosure that Nixon would not be named. One problem is that some and maybe most of the staff agree with Feldbaum's memo. And if I could take a moment to explain, the memo says we should indict this guy, forget about impeaching him. We have enough to indict him. It came up at the staff meeting, and Jaworski says, well, we've already passed that. Don't worry. I've already agreed with Sirica that we will not indict him. That's the job of the House of Representatives.
I find this to be remarkable. This is a future dean of Harvard Law School, Professor Vorenberg, who writes, Jaworski told them he'd already reached an agreement with Sirica, which Professor Gillers to me means pending or impending. I want to talk to you, Judge, about can we charge the president criminally? What do you think? And they come to an agreement that he has to be impeached. He can't be criminally charged.
Well, you see, here is why the language of the ex parte rules is too narrow to address this content, but other rules would. The judge is stepping out of his responsibility as a neutral umpire. He's becoming a cheerleader. He's becoming a supporter, an advisor to the special prosecutors. And, you know, if this were known at the time of the trial, I would expect that there'd be a motion to recuse him based on the ground under Section 455, today, 455, that his impartiality could reasonably be questioned. Because he is too immersed as a player in this story.
Professor Salzberg, what do you think?
I actually do think that there's a pretty good argument that whatever agreement this was, it had to involve a discussion on the merits of an indictment. To me, it does implicate the ethical rules. I can't imagine a judge sitting down with any prosecutor and let's talk about whether we should indict somebody. I mean, that has got to be so grossly improper. The fact that it involves the President of the United States, to me, isn't the important thing. It could be a low-level drug offender, and it would be just as bad for a judge to have a conversation about whether or not a person should be indicted.
Well, let's put this in context. Professor Salzberg, I'm sure you share my memory of the mood of the country at the time these events took place. When you had agents of a sitting president attempting to spy on the opposing political party to help him, meaning the sitting president, get reelected. People thought that it could spell the end of our Republican form of government and our democracy. Does that in any way, Carolyn, color your view of whether this was a wholly inappropriate conversation to have with between the special prosecutor and the judge? Oh my God, we have a president who may have engineered criminal behavior that bordered on a coup to somehow cut the head off the Democratic National Committee. What do we do with him?
Well, so I would like to answer that in two ways. One is what I would hope I would think, and the other is what the influence of the times would likely be, and I hope I would align myself with following the rules of ethics and law. But I can understand how a situation, that's sort of like, the ends justify the means kind of an argument. But still, I think it is quite clear that this was inappropriate no matter what set of circumstances the country was facing. Because if we do not abide by these rules, and this is even more than just the rules of ethics. This is sort of separation of powers and other things here, because it sounded to me, and again, I read things into some of this language, that there was maybe some discussion about whether this was more appropriately in the legislative branch than in the judicial branch or the executive branch for the prosecution, because they were going to defer it to go into Congress for an impeachment proceeding. But in any respect, whatever it is, it's inappropriate both for Jaworski and Sirica to have come to any kind of an agreement on this. Isn't it the grand jury who actually gets to decide that?
Judge McKeown, you get the last word.
Well, my last word would just be to affirm what everybody said. We're talking about a subject that should have been discussed within the prosecution staff, Department of Justice. This is prosecutorial discretion. First, you have a legal question of whether the president may or may not be indicted. That's one for them to resolve, at least initially, before it comes before the courts. And then secondly, whether it made political, legal, or common sense to do that. That, to me, doesn't seem to be the role of the judiciary. And once you start merging these, and you have a judge basically either steering or playing a role in this kind of a discussion, I worry that, down the road, you've really changed what the role of the judiciary is. And we pride ourselves on having an independent branch, the judiciary. This would totally undermine and suggest that that's not the case in this particular instance. And even though there's a mood of the country, which you reference, and the concern about whether this could cause a constitutional crisis, I do think that the public would be outraged to think that there was some backroom deal being made about this that involved the judiciary.
Why don't we move on to document number 7. When I was in practice, and since I have been fortunate enough to be on the bench, I have heard lawyers say, I probably said it at one time or another, we filed whatever document we filed to educate the court. And generally those documents are interminable, they're unnecessary, and I may or may not be educable, but I do have limited time. With that in mind, I'm going to ask Jeff to summarize what document 7 talks about, the so-called roadmap.
Thank you. We have here a memo from Phil Lacavara to Leon Jaworski, dated January 21st, 1974. And the memo, at its end, it's going to be 4 slides to get there. The memo says we've got this idea on how to get information from the grand jury to the House Judiciary Committee, and it's pretty creative. And we need to warn Judge Sirica that we're going to recommend it so he doesn't reject it out of hand. So it is a memo to Jaworski recommending an ex parte educational meeting with Judge Sirica. If you agree that presentment in lieu of indictment or non-action is the proper mode to pursue, there remains the question of procedure, specifically the relative rarity in which presentments, these are by the grand jury, are filed in federal courts makes it desirable to advise Chief Judge Sirica in advance of this proposed course. And then the next page, it would be most unfortunate, for example, for the grand jury to return a presentment, that's a report, without forewarning, and then have the judge summarily refuse to receive it because of his lack of awareness of the basis for such a submission. And then the third page, And this is the procedure of how we're going to go about doing this. If the grand jury indicates its tendency toward returning a presentment, we should schedule a conference with Chief Judge Sirica to apprise him in advance of this possible development. I'd be prepared to submit a memorandum of law to him at such meeting if he indicated an interest in receiving it. And then at the end, at any such meeting, we should recommend to Judge Sirica that the presentment be received by him under seal, with disclosure only of the fact the grand jury has made a submission, and that the White House be given 10 days to review the presentment and make objections to its filing and transmission.
For those of you who in the audience who aren't absorbed in the arcana of grand jury practice, most people associate federal grand juries, at least, with the return of an indictment. The Fifth Amendment to the Constitution says that no person shall be called to answer a charge, a felony, except on return of an indictment by the grand jury. The federal grand jury, it's unusual, but the federal grand jury also has the authority to return a presentment, and that's often interchangeably used with the concept of a report. You don't hear about it very often. There are two kinds of grand juries. I don't want to get lost in the weeds here. One, by statute, authorizes the organized crime grand jury, which I'm suspecting the Watergate grand jury was not, but I don't know.
Preceded the law.
Okay. It allows the return of a presentment explicitly, but not to address criminal matters, to address matters perhaps of malfeasance in office, providing they're not criminal. And they give the person assailed in the report the opportunity to be heard both before the grand jury and publicly. This was what we call a regular grand jury. The authority of a grand jury, a regular grand jury, to return a presentment is by no means clear, although it has been done and I imagine will continue to be done. Here we have the Special Prosecutor Task Force saying, we want the grand jury to return a presentment, and as we'll see going forward, the purpose of that is the presentment can then be provided to another branch of government, the House Impeachment Committee, which can't get this evidence on its own, and so we'll put it in a presentment and get it over to the House. Now, Judge Sirica may not know what the heck we're doing here, and so we don't want him to screw this up. And so just as Judge Sirica said to Earl Silbert, don't screw this up, I view this as the Watergate special prosecutor saying, we're going to tell Judge Sirica what we're going to do, and we're going to explain the legal basis for it. We'll give him a brief if he needs it, so he doesn't screw it up. What do you think, Professor Salzberg?
At first reading, I thought this is as outrageous as some of the other things we've talked about. But the more I thought about it, the more this is a close call for the reasons that I think that you've articulated. And that is that at the time, Rule 6E of the Federal Rules of Criminal Procedure was very narrowly written, only authorized disclosure of grand jury materials for use by federal prosecutors, or at least people in the Department of Justice. It didn't say anything, as you know, because you've written about this, about presentments, but there was a common law tradition of allowing presentments to charge malfeasance or nonfeasance in office on non-criminal matters. The problem here is there can't be much doubt that what they thought they were doing was filing a report which was about criminal matters, because that was their whole investigation. And so they basically were in a position, it seems to me, of being unsure of whether or not the common law could be extended this way, and didn't want to have the grand jury run through its paces, submit this to the court, which would have been Judge Sirica, and as was said here, and then have him say, you can't do this. At the time, the presiding judge of the grand jury basically address grand jury matters when someone claimed that there was an impropriety. Someone raised an issue that there's an impropriety, the judge would hear what that allegation was. And I think the independent or the special prosecutor here is concerned that it may be pursuing an improper means of charging and thinks that this is administrative, basically, in part. The problem is it's almost inevitable that if you're going to talk to Judge Sirica about this, you're going to have to get into the merits. This is why I think it's a close call. Surely Judge Sirica would need to know what the presentment might say to know whether it fits the common law or not. And that would be, I think, totally improper. And so I don't think the motivation here was a bad motivation. In some ways, I think they were torn on how best to proceed. And one last thing, the largest criticism historically about presentments has been that typically when the grand jury issues them, they become public. And the charge has been that if you're named in a presentment, you have no opportunity to defend yourself because there's no case. But at least here, they were trying to design a procedure that looks like it was intended to provide some fairness that typically was not associated with presentments.
Jeff, what happened to the presentment after it was presented to Judge Sirica by, I believe, by Mr. Jaworski?
Yeah, two items of information. In Jim Vorenberg's handwritten notes, and they're in the written materials but not on a slide, it says S liked the format of the Lacavera report. So they cleared the format beforehand. And it says Jaworski says he urged Sirica not to hold a hearing that would give the White House time to delay on this. But in fact, he did hold a hearing. He ruled that it could be forwarded to the House of Representatives. That was appealed, and the appellate court upheld the right to send it. And so what is described as a 55-page report with a briefcase of physical evidence was dispatched to the House Judiciary.
So just so we're clear, Judge McKeown, because we haven't connected all the dots here. What the special prosecutor was asking Judge Sirica to do was to receive this presentment, which was sealed, provide it to the House Impeachment Committee, along with materials that had been acquired by the grand jury to aid the House Impeachment Committee, which had tried to get these materials on its own from the grand jury, but was unsuccessful, to help the House Impeachment Committee put together its case. And all of this was done on an ex parte basis until the actual hearing before Judge Sirica. What do you think, Judge McKeown?
I think the key point, if true, that we have to look at is that basically the prosecutor using the judge as an intermediary to help the Congress. And that's where, again, you're blurring the lines. And there are some issues within the memo about scheduling, but I don't think this kind of timing is ordinary scheduling where you're trying to game the timing in prosecution of this magnitude and that has all these moving parts going on. So again, having the judge play some kind of role where he's in effect coordinating some of these parts seems to me to be where the line is crossed. But again, there's a lot we don't know from these memos because we don't have any actual transcripts. We don't have very many other contemporaneous documents of what happened, but they all hint at, by now, Jaworski feeling that he has a friend on the court, so to speak, and that the court can facilitate their ultimate objective. And of course, that's not the role of the judge. So I think you have both an appearance issue, you have an ex parte issue as well.
Professor Gillers.
Well, I read the document as saying, before we prepare this presentment, shouldn't we talk to the judge, let him know we plan to do it to make sure he'll receive it so we don't prepare something he doesn't receive? So at this point, it doesn't yet exist. And if that's the sequencing, then I think it is inappropriate, because they're bringing the judge into the lawyering decision. If they think a presentment is correct and they think the grand jury has the authority to do it, they should do it and give it to the judge with whatever memo they want, saying that it is appropriate for the judge to receive it. But they shouldn't go to the judge and say, can you give us a green light on this strategy before we implement it, because we want to know in advance whether or not you'll receive it.
Last word, Carolyn.
So just, I agree wholeheartedly with Professor Gillers on that. I also think it is, as we have spoken about from the beginning of this, where you see that the judge is the one reaching out at the beginning. Now we are solidly in a move by the prosecutors themselves to go to the judge for an ex parte communication and embrace him as a team member of the prosecution team to make decisions with them along their strategy. And that, I think, from my mind, in this document makes me perhaps the most troubled about what the prosecutors have done here.
Can I ask you a question, Judge?
Yes.
When I remember well, when I was sitting there with my little baby son watching all these proceedings, and I was thinking, boy, I was so proud of the way the Senate committee seemed to conduct its business. There's Sam Ervin and what's his name from Tennessee, Howard Baker. And together they seem to be Democrat, Republican. They seem to be wanting to see...
Where Fred Thompson got his start.
Right.
Yes, exactly.
See justice.
Everybody thinks he's just an actor.
Right.
And we had Judge Sirica, as you said, became, a common face, and Sam Dash. And I was really proud of all these people. I mean, it looked like they were heroes, and, and Nixon was what he said he was, and he was a crook. So the question I have is, when we look back on all this, don't we have to reassess our judgments about heroism and actually whether all three branches didn't get a little tarred here?
Well, it's easy to say that in retrospect, and I try very hard to resist putting today's standards on yesterday's behavior, although both you and Professor Gillers have gone to some considerable length to explain that today's standards weren't that different than yesterday's standards. And again, I have raised the context, which is a time of national crisis. Having said all of that, and having shared your pride in what I thought were incredibly dignified proceedings that were trying to reassure the country we're going to get to the bottom of this, it does seem to me, to some extent, the bloom is off the rose.
I think we do have to be careful about what has been called presentism.
Yes.
Visiting.
Yes.
Visiting the values and the accepted behavior of today on the behavior of people 40 years ago. Even if the text of the rules are not that different, the informal understanding about how people behave might have been quite different. And so we should be considerate in not imposing a new regime of understanding on how people behaved 40 years ago. Now, there are limits to that, of course. We shouldn't excuse anything. And maybe the behavior 40 years ago was unacceptable then, but we should be aware of that risk.
What do you think, Jeff?
Well,
I'm giving you a softball pitch.
I think we have two more incidents to review, which I eagerly look forward to, and then I hope to be given an opportunity in summation too. Item number 8.
When did I lose my job?
Item number 8, and it's very closely connected with number 9. And there's no slide on number 8. The indictments came down on March 1st, and Judge Sirica appointed himself to preside over the cover-up trial and the defendants sought mandamus from the D.C. court to kick Sirica off. And they asked for three things. They said that he shouldn't be allowed to determine venue because he'd prejudged it. He'd already announced publicly that the defendants could get as fair a trial outside the district as in the district. They asked for the choice of who to preside to be made by a three-judge calendar committee that already existed. And what the purpose of this slide, they asked for an evidentiary hearing on their suspected ex parte meetings that Sirica had with the prosecutors. And the only thing they could cite on appeal were two newspaper articles, one of which is reproduced in your written materials. And it just says, and I read it to you at the end of the article, after Cox met with newsmen, he conferred privately for 15 minutes with Judge Sirica, and without further explanation, and the judge, without further explanation, scheduled a hearing for today. And surprisingly, maybe not surprisingly, but the ACLU submitted an amicus brief, again in your materials, of 3 pages saying, look, they deserve an evidentiary hearing to explore whether the judge has been meeting privately with the prosecutors. The D.C. Circuit rejected out of hand, but our issue for discussion on item number 8 is if you were on the circuit, were these two newspaper articles, only one of which I managed to find, was that sufficient to agree with the defendants there should be this hearing?
Well, I certainly don't want to suggest how I would rule on anything. I'm not on the circuit, but I wouldn't want to suggest how I would rule on anything. But I can say we're looking at this document, and it's almost as though knowing now that John Wilkes Booth was going to go to Ford's Theater in April of 1865, would it have been wise to have a metal detector outside of Ford's Theater? Well, of course. Knowing what we know now, should there have been an evidentiary hearing? Well, of course. But because a newspaper has an article that the judge met with the prosecutor, is that enough to warrant the issuance of a mandamus, either removing the trial court judge or ordering him or her to hold an evidentiary hearing on whether or not the newspaper article is correct? I don't care how important the case is. I don't think that's enough. What do you think, Judge McKeown?
Well, the mandamus standard is extremely high in terms of it's an extraordinary remedy of where the Court of Appeals is, in effect, reversing or inserting itself into the district court process. So mandamus writs are issued, and they're particularly issued where there could be no other remedy, whether it wouldn't come out on appeal, where it's an extraordinary situation. I'm only looking at it going backwards, not about how someone might rule today, but to say on the basis of a newspaper article that doesn't have any content as to what the meeting might have been about, and we've all acknowledged that there can be legitimate meetings between the prosecutor and the chief judge with respect to certain aspects of proceedings and scheduling, it's probably not a surprise that the mandamus was denied. Looking backwards, of course, it would have been very interesting to know what would that evidentiary hearing have looked like, and would the documents that we're seeing now, would these documents have surfaced? Would this kind of testimony have surfaced? Because they had a suspicion, but they didn't have anything more than a suspicion at this point.
What do you think, Professor Salzberg?
I agree with Judge McKeown. I can't imagine an appellate court forcing a hearing or removing the judge based on these articles. Even though I would say that back then the press was generally, I think, held in higher regard in many quarters than it is today, because of we didn't have the internet, we didn't have all these.
You ever see His Gal Friday?
Yes. But it just wouldn't have been enough. But to me, what's really interesting here is we see this today. It was clear that the lawyers around for the defendants, they could feel something was wrong. They just felt it and just couldn't prove it. I mean, we have instances like that today.
Do you, Steve, do you think it would have been appropriate for the appellate court to ask for a response to the mandamus motion, even in camera, to find out what, if anything, was behind?
Judge McKeown, who responds to a mandamus motion? Is it the other side or is it the judge himself?
Well, it depends. The court can ask for a response from the judge, and that's discretionary with the court. I've seen it in some instances. It's unusual, but sometimes there are circumstances that the parties are not familiar with, and a judge will weigh in on a mandamus. But that would be a case that it wouldn't be in a usual case.
Two quick observations, if I could. I believe, I'm not positive, I believe the special prosecutors worked with the judge on his response. And
how do we know that?
I think there's a correspondence between the two. And I believe, I'm quite sure that in the prosecutor's own response, they were silent on this. They just didn't address the request for an evidentiary hearing. So you don't have a denial that there were no ex parte meetings. You just have silence.
But in response to Steve Giller's question, I just don't think that a typical appellate court is going, without evidence, is going to just say, we're going to make the judge respond. It would be odd. Not impossible. I mean, I once had a judge on the Third Circuit here, chief judge, say that we know a lot, he said, about which district judges, we absolutely trust, and which ones, when we get an appeal or a mandamus, we look very carefully at. And so there are unusual situations where you might get a response, but at the time, I think people had a lot of confidence in Judge Sirica.
What do you think, Carolyn?
I think that there's no way that the court would have done that on this evidence.
I mean, to pick up on Professor Giller's presentism, as I say, we're looking at the Lincoln assassination in hindsight. If appellate courts were to allow mandamus, every time somebody smelled something funny, the district courts, I don't think, could do their jobs. And I think that's why the circuit courts very wisely have made mandamus, as Judge McKeown said, an extraordinary remedy, because you're in state court in Pennsylvania, mandamus may be had only if the court acts outside of its jurisdiction, meaning there's no lawful authority for what the judge is doing. In federal court, it's not quite that severe, but it's close, and it should be. And again, not knowing at the time what Jeff has since uncovered, I don't see how the circuit could have ordered Judge Sirica, Leon Jaworski, or anybody else to respond to this. I don't think at the time it would have been an appropriate thing to do. Given what we know now and what we're about to find out from Jeff with the final document, it's quite another matter. Jeff.
Thank you. We'll go to number 9, and number 9 involves several slides, but I think we can short-circuit them. This has to do with the prosecution working hand in glove to enable Judge Sirica to appoint himself to preside over the Watergate trial. And we start with a memo, another Jaworski confidential file memo that surfaced only relatively recently, and we're going to read you the first paragraph. On Monday, February 11th, I met with Judge Sirica. I need to add something. If you go back to that letter where the 4 prosecutors met with the 2 judges, we highlighted a sentence that predicted the 3-month indictment would come down at the end of January or the beginning of February. And that was important to Judge Sirica because on March 19th, he would turn age 70. He would have to step down as chief judge, and he couldn't appoint himself to preside over the Watergate trial. So this is a meeting where the first week of February has passed and there's no indictment. So I read you the first paragraph. On Monday, February 11th, I met with a judge, at which time several matters were covered as we sat alone in the jury room. He again indicated, provided the indictments came down in time, he would take the Watergate case. Then we skip a little bit about why. And then he says, and then Jaworski writes, Sirica expressed the opinion these indictments should be returned as soon as possible. Now we're going to stick on that topic, but the next 3 slides talk about the ability to bring this indictment sooner. And here we talked about the Vesco case, and he merely expressed the thought perhaps a sealed indictment might be of some help. And very quickly, the Vesco case jury is being seated in New York City. John Mitchell is indicted. Mitchell is going to argue if an indictment comes down in Washington, D.C. for the cover-up trial, it poisoned the jury pool in New York. So there's other correspondence, but Jaworski and his staff are saying...
That's the Vesco case that's being referred to.
We can't bring the indictment in Washington, D.C. until the Vesco jury is sequestered. So what this is saying is Sirica is saying, well, we don't want too big a delay. Maybe you could issue a sealed indictment down here, won't poison the jury pool. I can still appoint myself in time, because he's very worried about this window of time. Then if you have the time to read the rest of this memo, it goes back to whether there is that roadmap. And he's describing lobbying Judge Sirica on convincing him that they can do that presentation. But we've covered that. We don't have to cover that now. We'll go to a subsequent memo. This is another Jaworski memo dated March 1st. March 1st is the date that the indictments, in fact, were handed down. They beat the deadline by less than 3 weeks of letting Sirica appoint himself. And this is Jaworski's memo to his file. And he says, on the morning of March 1st, I met with Judge Sirica in chambers at 10:30. Now, the hearing where the indictment is going to be handed down is at 11 o'clock. We reviewed the agenda. I told the judge I would ask the court to specifically assign the case. And then on the next page, he describes that hearing on March 1st when they handed down the cover-up indictments. The judge in open court asked if I had any further comments. The indictments have been announced. And I stated, due to the length of the trial, conceivably 3 to 4 months, it's the prosecution's view that under Rule 33C, this case should be specially assigned, and we so recommend. This meant Judge Sirica could assign the case to himself, which he did do by order entered later that day. In the very next paragraph, this is after the indictment hearing is concluded. We met in the judge's chambers. I told him I thought all went smoothly. He in turn thanked me for my help. Judge's leaving today to talk to UVA. He'll be back on Sunday. I told him I was going back to Texas. I'd be back on Tuesday. And the last sentence of this memo, we both agreed we would call each other in the interim if necessary. And I humbly submit to my illustrious panel, this is a partnership between the judge and the prosecutors to enable the judge to name himself to preside over the cover-up trial.
Let me take some issue with that. In my district, in other districts, there are times when matters are specially assigned, not off the wheel, as we say. For instance, if a member of the court or his or her family might be involved in a matter, the chief judge of the district will actually assign the matter, because otherwise it might come up before the judge whose family is involved, or with particularly huge or burdensome matters, the chief judge can specially assign the matter and not just put it on the wheel. With that in mind, Steve Salzberg, and I'm sure that was the case in 1974 in D.C., what do you think of this conduct, assuming it happened?
I don't have any problem then, and I don't have any problem now, with the chief judge taking a look at a case and saying this is going to be monumentally difficult or especially time-consuming, and specially assigning it. What I have a problem with are the ex parte communications with the prosecutor, where the prosecutor is basically agreeing with the judge that should happen, and they have this deal where the prosecutor is going to return the indictment before a certain date, and then recommend that there be specially assigned, knowing that they've already talked about it, that Judge Sirica will assign the case to himself. It's the kind of dealing that basically means that Judge Sirica is beholden to the prosecutor because he really wants the case.
Professor Gillers, it seems to me that what Judge Sirica is saying here is, hurry up with the indictments or I won't be able to assign these cases to me. Do you disagree with that reading?
I don't disagree. And what you described is not what happened here, as Steve Sulzberg says. The judge is applying to be the judge and seeking the help of the prosecutor in enabling him to ensure his own appointment to the case. And there is, at least to the public, the potential inference of a subtext. You want me, Mr. Jaworski, to be on this case. And I'm going to assign it to myself if you just hurry up and make it possible for me to do so. None of this should have happened, which is not the same as what you described, and it's not the same as lawyers timing a matter to ensure that it comes before a judge they think will be sympathetic, where the rules of the court enable them to figure that out, where it's not random. That's okay. It happens. We understand that. But this is an agreement and restraint of trade. and what the judge is doing is making a deal that is unseemly.
Carolyn, I know you wouldn't, but lawyers have been known to judge shop.
Oh, certainly. And at every opportunity, many, many lawyers will.
Well, what's the difference between that and this?
Well, because I guess the difference between that and this is that, and first of all, it depends on what that is. I mean, judge shopping, and there's judge shopping. I mean, you might decide to file in a particular jurisdiction because you have a better chance. So those things, I think, are all part of the trade of litigation. I'm sorry to say, I'm revealing my own personal ethics, if you will, but I wouldn't do anything more than that. But the thing of it is here, I think it was more than just applying for the job, but I agree it was. I think here it was creating the drama, writing the script for the courtroom. What you should say to me, what I should say to you. You say, do you have anything more to say to me? Yes. We would ask, we would let the court know this, and it was all prearranged. So this.
And then how do you think it went?
Yeah, and then how do you think it went? Well, we did pretty good, didn't we? High five, And so in my mind, I remember when I first read this, I was like, you have got to be kidding me. I couldn't believe it.
Well, I think what you have here is, we talk about judge shopping, but this is case steering, is the way I view it. And that is that the judge is setting up the predicate so the case can be steered to him. Now, it's quite common in most districts, of course, there are rules set out as to case assignment, but generally it's preserved that the chief judge retains some discretion over certain kinds of special cases. And it's very likely that even after he passed as chief judge, that the next chief judge may well have assigned it because of longevity and experience, but there was no assurance. So I view this as him creating an insurance policy, if you will, through this agreement that's set up. So there's both the case steering problem, and then there's, of course, as Professor Gillers referenced, there's the deal that is being made here, at least according to these documents, between the judge and the counsel. So you have, I think, we don't know everything that happened, but this raises a lot of issues, and if these facts had come before a court of appeals, that might have been something different.
Well, as a way of finally addressing this remarkable document, why do you think, Steve Gillers, it was created? I played devil's advocate and said there are ways to specially assign cases, but I happen to agree with you. I don't think this was that. This was extra specially assigned, and I agree with what everyone else has said. But why would Leon Jaworski write this? Why would he keep it? Why would he not destroy it, knowing it was going to go? Where did you recover this from, Jeff? Was it in the National Archives? Or?
Yes, but it surfaced in his papers at Baylor University
At Baylor.
Before the archives got hold of him.
Knowing that there was a distinct possibility that somebody like a Jeff Shepard or somebody else would uncover them, is it that he really didn't think he was doing anything wrong, or is it something else? We're all playing armchair psychologist here.
Well, in my experience, lawyers and judges don't have the knowledge of how the rules we're talking about operate at a deep level. Now, Sam Dash taught legal ethics. So the real puzzle for me is Sam Dash, because he and I would have conversations about legal ethics. He knows this stuff. So the fact that he was unaware of the limitations on his own behavior is interesting. The second explanation, I think, is that we all think that we're really good people, right? We are good people. We're going to do the right thing. No one has to worry about us. You have to worry about other people. The rules are made for other people, not us, because we have great values. And I think that Jaworski and Dash, in the service of a noble cause, as they both viewed themselves as being part of, may simply have ignored the fact that there were rules governing even their noble service.
Hindsight is 20/20, Professor Salzberg. It has since come out that Judge Sirica and Richard Nixon did not like each other. And if we assume that in part motivated Judge Sirica, and I understand Leon Jaworski had a job to do, do you think that this memo, this document 9, is in part the product of a guilty conscience?
I don't think it's a guilty conscience. It's quite the opposite. I think that what you said earlier is exactly right. There was such pride in getting rid of Nixon. I mean, everybody involved was proud of their effort. That I think that Jaworski wrote this because it was what he did, and he was quite proud of the fact that it all worked out. The folks who were prosecuted for the cover-up were convicted. Nixon resigned before he was impeached and was disgraced. Justice was done. And Jaworski was a big part of it.
And this is how we fashioned the stake that we drove through the president's heart.
Yes.
You agree with that?
I do. I think that there is that everywhere in our time today. People believe, and we all have to resist it, that the ends don't justify the means. And I don't think they were looking at that at the time.
Judge McKeown?
I don't have a degree in pop psychology, so I don't think I have anything to add.
Very well. I think we have a very few minutes left. Does anybody have any closing remarks he or she would like to make?
Well, I would just like to say that I hope in 40 years, when Jeff Shepard writes the definitive book on the Mueller investigation, we can all come back here and, using presentism for 2050, evaluate that.
Yes, and I hope long after I've assumed room temperature that Jeff Shepard has too, because I'd hate to think what he would think of the things I've done. Does anyone have anything else he or she would like to say?
Not I.
Then I would really, it's been a great privilege and an honor to moderate this discussion, and I've never been so proud of the ALI, and thank you all.
Thank you for joining us for Ethics of Ex Parte Communications, today's lessons from the Watergate Special Prosecution. This will conclude today's program.